Hi everyone, good morning. We are the labor group. So before we proceed to the labor law, let's start our discussion. What is labor? Labor can be work, employment, physical or mental effort, and it may be considered as property. So I'll introduce the labor law according to 1987 Philippine Constitution Article 3, Section 1, the Bill of Rights. No person shall be deprived of life, liberty, or property without due process of law. It means that our employer is not allowed to terminate us without due process of law. So, what is labor law? The labor law or labor code of the Philippines stands law governing employment practices and labor relations in the Philippines. The decree that enacted the Labor Code on May 1, 1974 by President Ferdinand Marcos was the Presidential Decree number 442. Labor Code thereby revising and consolidating the labor and social laws to afford protection to labor, promote employment and human resources development to ensure industrial peace based on social justice. So basically, the labor law prescribes the rules for hiring, termination of employees, and etc.
The Labor Code of Philippines, which governs employment relationships, is used here in the Philippines. Additionally, it applies to foreign nationals who works here. Employers must be aware of the do's and don'ts of the Labor Code in order to avoid running afoul of the law in a nation that adopts pro-labor policy with guaranteed secured of tenure. Different categories of workers are given different rights to statutory requirements, length of engagement, and other benefits under the law. The first type of employment is the regular or permanent. It is when an employee performs activities that are usually necessary or desirable in the usual business or trade of the employer. They enjoy the benefit of security of tenure provided by the Philippine Constitution and cannot be terminated for causes other than those provided by law and only after due process is given to them. Under Article 281 of the Labor Code of the Philippines, the maximum length of probationary employment shall be 6 months and is counted from the date an employee started working. When the employee is not terminated after the 6-month probationary period, it shall then be considered regular employment. It is important to note that the employer must notify the employee of the probationary period and the standards they must satisfy on or before the end of the probationary employment. If the employee is not properly notified of the arrangement, then they are prescribed by law to be classified as a regular employee from the time they started working for the company. The next type of employment is the fixed term or contractual. Fixed term employees in the Philippines are also known as the contractual employees, where they are engaged to perform a job, work, or service for a predetermined date of completion, or where the employee has a specific date of termination. The term of contract will be mutually agreed by both parties. Employees will be automatically terminated once the contract ends. During this term, fixed-term employees cannot be terminated without due processes and cause under the Labor Code of the Philippines. The next type is seasonal employment, which applies where the work or service to be performed is seasonal in nature and the employment is for the duration of the season, according to Article 280 Labor Code of the Philippines. This type is common practice to retail, food and beverages, hospitality, and other related industries as augmentation to their workforce to cover for the demand during the peak seasons. One example is during Christmas, where a group of workers will usually be engaged for the duration of the promotional event. They are mostly part-time or temporary workers that help with increased work demands for that period. These workers will be temporarily laid off during off-season but re-employed when their services are needed. The employee relationship is never severed but only suspended. The fourth type of employment is the project employment. A project employee in the Philippines is unemployment for a specific project or undertaking. The duration of the project will be set and determined, where employees will be complete or terminate engagement once it ends. In the Labor Code of the Philippines, it is important to specify the project one is employed on. Additionally, there must also be a clear agreement on the completion or terminated of the project at the time of employment. Predetermining the duration of the project employment is important if determining if employee is a project employee or not. They may acquire the status of a regular employee when they are continuously rehired after a completion of a project or undertaking, else they will automatically be terminated. The last type of employment is the probationary employment. It exists when the employee upon his engagement is made to undergo a trial period where the employee determines his fitness to qualify for regular employment. Based on reasonable standards made known to him at the time of engagement, the employer shall make known to the employee the standards under which he will qualify as a regular employee at the time of his engagement. Where no standards are made known to the employee at that time, he shall be deemed a regular employee.
The process through which an employer determines the suitability of an applicant for employment is referred to as selection and hiring. Now, let's dig a little deeper into an employer's first power. An employer has the right to hire its own personnel. In general, labor laws do not allow for interference with the employer's business judgment. Thus, management has sole authority over determining the credentials and suitability of personnel for employment. Except in circumstances of unlawful discrimination or those allowed for by law, the employer is free to determine all aspects of employment, from hiring to firing, using his own discretion and business judgment. Now, are there any rules in place that govern or limit an employer's right to hire its own employees? First, let us review our labor code. This labor code of the Philippines contains Article 136, which states it shall be unlawful for an employer to require as a condition for or continuation of employment that a female employee shall not get married or to expressly stipulate that upon getting married, a woman employee shall be deemed resigned or separated.
Power to hire. Employers have the right to hire their own personnel. Generally speaking, labor rules do not permit interference with the employer's business judgment. Accordingly, it is exclusively on management's responsibility to evaluate applicants and decide whether or not they meet the necessary criteria for employment. Any and all aspects of employment are up to the employer's discretion and good judgment. Power to fire. In the Philippines, dismissing an employee is a delicate process that requires a fair or legal reason as stipulated by the Labor Code. The reasons for dismissal are spelled out in detail in the Labor Code, including Articles 282, 283, and 284. There are two types of reasons that an employer might fire an employee. First is employer-related, second is institutional. There is always going to be a defining moment in favor of the worker. So it is the employer's responsibility to prove that there were just cause for the dismissal. In the events of legal action, an employer who terminates an employee's job without providing an authorized or justifiable reason will be held to various obligations. Should the dismissal be unjustified, the worker has the right to be brought back into the organization with all of their seniority and perks intact.
Topics to be discussed under power to control: wage, salary, work hours, overtime pay, night differential, and SSS law. A wage order number NCR-23 issued on May 13, 2002 granted the employees a wage increase of 33 pesos from 537 to 570 pesos. Workers in the non-agriculture and agricultural sectors also had a raise from 500 to 533 pesos.
Wage, as defined by the Labor Code under Title II of Wages, Chapter 1, and to summarize what's written in the PowerPoint, the incomes or earnings payable by an employer to an employee under a written or unwritten contract, including the board, lodging, and other facilities, is referred to as payment to an employee. But take note that the fair and reasonable value written in the PowerPoint shall not include any profit to the employer or to any person affiliated with the employer. Now let's talk about salary. Salary. A salaried employee is paid a fixed amount of each month. Their earnings are typically with paid vacations and public holidays, including health insurance and other benefits. Take note that no salary can be below the minimum wage. Salary and wages are widely used interchangeably, and their meanings are often the same but not always. Wage is a pay rate per hour multiplied by the numbers of hours worked, while salary is a fixed rate paid out each month as it was calculated annually and divided by 12.
Hours of work written under Article 83 to 84 of the Labor Code. Normal hours of work of any employee shall not exceed 8 hours a day, and if it does exceed, there should be overtime pay. Take note that hours work shall include all time during which an employee is required to be on duty or to be at a prescribed workplace, all time during which an employee is permitted to work, and rest periods of short duration during working hours shall be counted as hours of work.
Let's tackle overtime. Any work after the normal or regular shift, which is 8 hours, is considered as overtime. Rest and breaks are both considered or counted as hours of work. Overtime pay are equivalent to 25% of your minimum wage. So if your minimum wage is 570 pesos, you should be able to receive 712 pesos and 50 centavos.
Night differential, written under Article 86 of the Labor Code. Every employee that works night shift is entitled to a night differential pay of not less than 10% of his regular wage for each hour of work performed between 10 p.m. and 6 a.m. Republic Act No. 8282, or also known as Social Security Law. A policy of the government to establish, develop, promote sound and viable tax-exempt social security system suitable to the needs of the people throughout the Philippines. This shall promote social justice and provide meaningful protection to members and their beneficiaries against the hazards of disability, sickness, maternity, old age, death, and other contingencies that may result in loss of income and financial burden.
SSS is a government-mandated insurance scheme for all income earnings and workers here in the Philippines. All SSS members who generate an income are expected to contribute to the fund on a monthly basis, with the amount determined by their salary range. They'll receive insurance benefits such as sickness, maternity, disability, retirement, even death and funeral, and income loan in exchange for the monthly contributions.